name is Brittany Mobley, and I will be presenting on a New York Times vs. Sullivan 1964 case. This is an image of L.B. Sullivan conferring with the local police officials. This is a snapshot of Heed Their Rising Voices, one of the most famous and most cited defamation cases with the New York Times vs. Sullivan, and was decided 50 years ago in 1964. This case was pivotal to freedom of speech and freedom of the press. The Petitioner newspaper published a full-page ad that alleged the Reverend Martin Luther King Jr. arrest for perjury in Alabama was a part of the campaign to destroy King's efforts to integrate public facilities and encourage black votes. Harvey Fireside created a book about the case in May of 1999. M. Roland Noshman was an Alabama lawyer who opposed the New York Times in a libel case that resulted in a landmark Supreme Court decision establishing greater leeway for newspapers and individuals to criticize government officials and other public figures. He actually died on November 24th at his home in Montgomery, Alabama. He was 91. Who are the parties to the case and what facts led to the dispute? The parties to the case was the U.S. Supreme Court vs. Sullivan, an elected official in Montgomery, Alabama. The facts that led to the dispute were alleging that Sullivan had been libeled by an advertisement in corporate petitioner's newspaper. The newspaper appeared over the names of 4 individual petitioners and many others. The advertisement included statements, some of which were false, about police action allegedly directed against students who participated in a civil rights demonstration and against the leader of the civil rights movement. Respondents claimed that the statements referred to him because his duties included supervision of the police department. Why did Sullivan feel his reputation was damaged by the New York Times publication? Sullivan's complaint alleged that he had been libeled by statements in a full-page advertisement that was carried in the New York Times on March 29, 1960, titled Heed Their Rising Voices. The advertisement began by stating that, as the whole world knows by now, thousands of Southern Negro students are engaged in widespread nonviolent demonstrations in positive affirmation of the right to live in human dignity as guaranteed by the U.S. Constitution and the Bill of Rights. The text did appear over the names of 64 persons, many widely known for their activities in public affairs, religion, trade unions, and the performing arts. Below those names and under a line reading, it said, "We in the South who are struggling daily for dignity and freedom warmly endorse this appeal." Appeared the names of the 4 individual petitioners and 16 other persons, all but 2 of whom were identified as clergymen in various southern cities. Although none of the statements mentioned Sullivan by name, he believes that the word police in the 3rd paragraph referred to him as the Montgomery commissioner who supervised the police department. So basically, he was being accused of ringing the campus with police. He further claimed that the paragraph would be read as imputing to the police and hence to him the padlocking of the dining hall in order to starve the students into submission. What are the elements of defamation? The elements of defamation are as follows. To prove premise in defamation, a plaintiff must show 4 things. He must show a false statement purporting to be fact, publication or communication of that statement to a third person, fault amounting to at least negligence, damages or some harm caused to the person or entity who was the subject of the statement. The plaintiff had to prove actual malice in the publication of the article. When an article is published and circulated among voters for the sole purpose of giving what the defendant believes to be truthful information concerning a candidate for public office, it is unable to be proven as actual malice. What was the U.S. Supreme Court's decision and why did it make that decision? The U.S. Supreme Court decided that the plaintiff had not proved actual malice, and a general verdict was returned for the defendant. The U.S. Supreme Court made the decision because the court sustained the trial court's instruction as a correct statement of the law, saying that the case gives rise to a privilege, qualified to the extent that anyone claiming to be defamed by the communication must show actual malice or go remedialist. This privilege extends to a great variety of subjects and includes matters of public concern, public men, and candidates for office. The U.S. Supreme Court concluded that such a privilege is required by the First and 14th Amendments.